arbitrate to enhance your state. Adjudication is your road to salvation. Hunt ADI is your destination.
Right, today I am joined by Tim Wallis, and Tim is a director at Trust Mediation, which is a very well-known mediation service provider in the UK, predominantly dealing with personal injury claims, personal injury disputes, and if I've got that wrong, Tim can correct me in a moment. Tim is someone who I have been aware of for many years, probably longer than both of us would like to recognise now, because it means we're getting older. But for some reason, we've never really sort of met too much or talked too much. I don't know why. Until recently, when Tim attended one of our AI for Mediators courses, and we had an opportunity to spend some time together, really for the first time, for as long as we can remember. So, Tim, welcome to No Disputing That. It's good to have you on the show.
Thank you, Greg, and nice to be here. And I think I do recall very vaguely a brief conversation, maybe even a coffee, when you were at the Chartered Institute of Arbitrators, which I know was many moons ago.
It was, yeah, a long time ago. God, I mean, that's the thing. We have met and we've said hello, but I don't think we've actually ever really sat together and had a conversation about anything. And so it'll be good to be able to do that today. So, Tim, I'm really interested in how you started off in a career in mediation.
Yeah, well, it's a long journey, Greg. It was in the 90s, I think. I trace it back to 1991. I was a member of the Civil Litigation Committee of the Law Society, and that year was a landmark for ADR for me because, firstly, the committee received a paper from Henry Brown, who told us about this new thing, ADR from the States. At least it was new to the Law Society and new to me. And I think it was about the same year that Andrew Ackland wrote his book, A Sudden Outbreak of Common Sense. And I think a combination of those things got me converted to looking at this. And part of my personality is I'm always looking at different ways of doing things. And I could see that ADR offered...
Good for a mediator.
Yeah, and a better way perhaps for clients. So I persuaded my firm to, it was a litigation firm, no longer existing, but called Croots up in the northeast. And I persuaded them to join both CEDA and ADR Group. A few years later, I trained as a mediator, and I continued to be interested in the subject because I think it was about 96. I had a sabbatical and visited the USA and Canada to study mediation. I was really interested in what was happening. I knew they were 15 or 20 years ahead of us, and I was particularly interested in the personal injury and the clinical negligence side. So that was a fascinating time I had there in three cities in North America. I think the next landmark came in 1998 when the Wolf reforms were starting to get going and into full swing, and I was lucky enough to be appointed to the Civil Justice Council to hold the ADR brief there. And I think for the next 10 years or so, on and off, partly as a member, partly as a guest, I was involved with the CJC, and together with Francis McCarthy, who is now a senior partner in Pattinson and Brewer, and also a founder director of Trust Mediation with me. Well, this was before the days of Trust Mediation, but Francis and I got involved in mediations hosted by the CJC and what was then called the cost wars, where you had the personal injury lawyers, claimants on one side, defendants and the ABI on the other, and the CJC, together with what was then the MOJ, with the Master of the Rolls, had an industry mediation. And I think we had about 4 or 5 of those over a number of years. And it taught me an awful lot about mediating multi-party claims with big numbers. And that was a fascinating experience which demonstrated another way in which ADR could work. Next up, I think Francis and I, together with some others, founded Trust Mediation in 2007. And then another part of my journey, I was appointed as chair of the claims portal, also known as the MOJ or the RTA portal. They wanted a mediator as chairman because they've got 2 sides of the board, insurers and defendants on one side and claimants on the other. And I had 10 years there as a fascinating time dealing with the dynamics of that. 2016 we really got going. That's when the NHS Litigation Authority, as it then was, changed its name to NHS Resolution, and we were appointed following a competitive tender, along with CEDA, to provide mediation services for the new NHS Resolution mediation scheme. And we've been doing that ever since, following 2 more successful competitive tenders. So you mentioned personal injury earlier on, and that's certainly the focus of trust mediation, but it does include clinical negligence. Excuse me. And most of I think the majority of our work over the last 10 years has been clinical negligence rather than personal injury, although we are seeing an upturn in personal injury now following Churchill and the changes to the CPR.
Yeah. I
think the other strands to mention are that it was, I think, about the same time as we got going with the NHS Resolution that I joined ICODA, the International Council of Online Dispute Resolution, and since that time I've had a great interest in the development of ODR, and now, as you know, AI as well with that. And so it's the 3 parts of my career: litigation, mediation and tech have all come together, and that's been a very interesting aspect of things. And just to finish off today, I'm still working with Trust Mediation as a director and a mediator, doing personal injury and clinical negligence mediations, and I'm also a member of Northwest Mediation Solutions, and for them I mediate commercial and agricultural claims. Fighting Farmers is my nickname for that part of the work. So that's the story in a nutshell. Greg, and, I'm sorry to take some time, but it's I've had to scoot through quite a number of years there, as you can work out.
No, I've realised now as well, when you've been doing something for a long time and people say, "Oh, can you just give me a recap of what you've done?" It's like, well, how long do you want it to be? There's like 30 years worth that we could go through. You just want the highlights. So when you I think one step missed out there maybe was were you a personal injury solicitor before you got
That's
into
right. Yes. Yeah. The law firm I was with, personal injury, also they acted for both sides. I was really, I count myself very lucky that when I did articles, which again shows my age, the firm I joined as an article clerk did 50% claimant and 50% defendant work. So they acted for trade unions on personal injury plaintiff work as it was, but also acted for insurers and health authorities, what we would now call the trusts. So I saw both sides, and I started doing claimant, then moved to the defendant. Personal injury moved to clinical negligence, and also some commercial litigation, partnership, and so forth. So I had a good mixed bag career, and professional negligence was particularly interesting at the time. But so a good mixed bag career as a solicitor. But I think when I visited the States and saw that they were settling big claims in a one-day mediation, it really opened my eyes. And when I came back from the States, I was involved in a large case which, or rather the partner I was working with was involved in it, and I recommended mediation. And after, I think, about 10 hours, everybody was very frustrated and thought it was a very bad idea. But an hour later, we had a settlement.
Yeah, it can be that quick, can't it, when people's minds change?
Absolutely. And so that was, it was great to have that kind of worked example from studying mediation, seeing other people do it, and then see a big case, which your firm was heavily involved in, moving from another 2 or 3 years of litigation down the track to a settlement. I didn't need much convincing by then that mediation was really good for my kind of work, for personal injury, clin neg, commercial disputes. But that I think was a clincher. I remember that day very well in Leeds, semi-subterranean room with the mediator disappearing for long periods of time. The people saying, "This is a waste of time, Tim. What have you got us into?" So that's a.
Yeah, it's surprising how often in a mediation you're sitting there a few hours in and everyone's thinking this is a waste of time. But then if you just give it time and carry on and develop, it ends up, more often than not getting to a resolution.
Yeah, I often say to people at the start of the mediation that this could get worse before it gets better. And sometimes it does. It's quite a lot worse.
Yeah.
But the number of times I've thought in a full day mediation at lunchtime, and sure it's the same with you, Craig, but lunchtime, 2 o'clock, 3 o'clock, you think, well, this is going nowhere. This is not going to be part of the one of the days where you go home having seen the settlement, and then it happens. It's part of the process as people get to the edge of the cliff and look down, and they look down again, and then think, you know what, we could live with something in that region, and that's the shift which comes. But the thing I've not been able to do, Greg, is to find out how to do it quickly. It does take time.
Yeah, well, good things take time. Something that you have touched on there, which I think listeners would be really interested to know a little bit more about, is how the whole NHS Resolution mediation process works in terms of clinical negligence.
Sure.
I remember when I was at Cedar, and we were it was just before you won that contract. There was a lot of conversations going on, and at the time, so going back sort of maybe 2014-ish, 2012, there was a lot of talk about, well, it'll probably never come off because getting all the people who need to be at a mediation was impossible. Because there were consultants, there were staff needed on operations and so on. So how have things changed now that we've got from that sort of situation where there wasn't massive buy-in, even though people thought it was a good idea, to now where it's much more commonplace?
Sure, well, I think credit has got to be given to NHS Resolution. Certainly, I remember Tony Allen of Cedar and myself for Trust Mediation put together a seminar inviting everyone involved, all stakeholders in clinical negligence. I think at the time you were mentioning 2012, 2014, and the question was, is the time right for a specialist clinical negligence mediation panel? And the answer from the stakeholders of that meeting was emphatically not. I think Trust, the NHS Litigation Authority, politically had to say, well, this is something we're open to, but there wasn't a great deal of warmth from anyone, and some solicitors said, look, this is highly adversarial. This is a fighting ground, and leave us alone because if we can't settle the cases, we tried them, and it's very adversarial. But it took NHS Litigation Authority to make a policy decision and saying, right, we're going to have a go for a changed approach and follow through on it. And of course, once they instructed their panel solicitors that this is what was going to happen, they did find takers, not from every quarter, but some claimants said, well, yes, we'll give it a go. And I think that both Cedar and ourselves established ourselves as neutrals, as independent neutrals, and fiercely so, notwithstanding that we had been appointed through a tender which the NHS Resolution ran. But I think once you get the paymaster saying, and any insurer could do this is what we're going to do, we are going to try this. And I think to the surprise of many, it did work. You mentioned having consultants and so on present, and that was difficult in the early days because of the huge demands on their time. So the mediations tended to be without them, usually, although on significant occasions, I remember one major case in particular where there were two of the treating surgeons present, and they took us through what happened on the operation, which had some unfortunate results. But generally speaking, that didn't happen. It is easier these days, of course, meeting as we're meeting now, using technology. And it is possible to get in either senior people from the trust if an apology is going to be made, or a clinician if their part is important.
And would people like that potentially join if the mediation was in person? Would you potentially have somebody still join using technology as well?
Sure, that's possible. And I would like to see. Traditionally, experts have been kept out of the of mediation, and their reports are available, and joint reports where the litigation is not developed. But I can see a scope for a kind of mediation hot tubbing, of actually having the experts attend online for a limited period where there is highly contested evidence. That's not something we've seen very much of, but I do think mediation is such a flexible process that you can tailor it to demands. And that's something I'd be interested to see. So that's something for the future, perhaps. But certainly, people being able to come in online for an hour or so makes it a very different proposition.
Yeah, we'll get onto the future in a minute. In the future, we'll get into the future. Just for now, just a question I'd be interested in you answering as an experienced mediator who's mediated for a long time. Do you think the actual mediation process, the way we mediate, has changed at all in the last 30 years? Or do you think we're still doing exactly the same thing, just maybe with different sectors and different parties?
Yeah, there are some changes. I think the core of what we call facilitated mediation, where the mediator is not involved in making any kind of decision or opinion, I think that has stayed basically the same, and it's a highly successful process. But when you say, well, what actually is it, and what's the definition of mediation, and what is the process? I was at a cyber conference held in the States last week and attended online, and one of the academics who's been involved in mediation for decades said that when they did some survey to try and tie down that question, they found out there are about 50 different forms of mediation. He says, so when you're trying to write ethical rules for mediation, how do you know what is mediation and what you're writing about?
Yeah.
So I know that there is a CEDA style. Some of my colleagues have been trained, very successfully trained by CEDA, and they've got a slightly different trial, a different format, a different approach to those who were trained by ADR Group and elsewhere. But I think that the essentials are the same. But there's also the indefinable input of the mediator herself or himself.
Yeah.
And because the process is one thing, but your personality, your experience, your gravitas, your influence, all of these things come to bear. So each mediation is a personal process, albeit on a formula which, in very generic terms, it looks on the face of it the same. But I have colleagues who would say to me, Tim, I would never do that. And I would say, well, I've seen how you don't do that, and I always do that.
It's true. I mean, we're on day 2 now of a course this week, so I don't teach day 2. I bring John, one of my colleagues, in, and we concentrate the whole day on people skills and interpersonal skills. And my argument for that, and I've trained with 3 or 4 other, in my career, I've trained 3 or 4 times as a mediator, and I've delivered training with other people. And the thing that I always felt that it needed more time on, so I wanted it in our training, was interpersonal skills and people skills. Because you can know all the theory in the world, you can know the process inside out, you can be really clever and quote case law and all the rest of it. But if you can't communicate with people and you can't get people to feel comfortable communicating with you, then what really is the point? So what we do today is we say to people, look, you've got your personalities. We're going to show you what you need to do, but we want to work with you to develop how you use those interpersonal skills and develop them, and that's what we do today. But then it all feeds into what you just said about personality, because you guarantee, we probably received very similar training at the beginning because everybody trained the same way. But we will mediate completely differently. Our styles will be completely different because we're different people. And when I talk about training, I say to people, it's like we're teaching you to drive, but once you get on the road, you've got the skills to be able to adapt to the different road conditions, and then you apply those skills differently in every mediation you work in, just like you would do every time you drive. But I think that the factor that really makes the difference in mediation is always going to be the individual.
Yeah, I couldn't agree more, and I commend your approach to training. I was privileged to attend a training which the American Arbitration Association ran for judges who were retiring from the bench in the States and then going on to be mediators. And I remember the professor starting that course said, I'm dealing with 15% of what you're going to do as a mediator. 15% is the processes and the mediation tools and techniques, and that's what we're going to teach you today. And the 85% is your background and what you bring. He said, no, I can't help you on that. You score 100% on the 15%, but you may not be a successful mediator.
Want to get smarter with AI in just one day? Try Hunt AI's introduction to ChatGPT. On demand, practical, and made for real businesses. It's just £20 at tinyurl.com/intro ChatGPT-1.
So, looking a bit at... actually, I'm going to go first with... I was at a show last night. I went to see Matt Chorley. Do you know Matt Chorley? Yeah, BBC journalist.
Very entertaining guy.
Yeah, he is. It was quite a surprise, actually. I thought it'd be quite a political heavy thing, but it was like going to a stand-up comedian. And he was very funny, and he embarrassed my wife at one point, which was also quite funny. I hope she doesn't listen to this, because I'll be in trouble if she does. And one of the things he talked about was MP's favourite biscuits. So I thought I was going to ask you today, Tim, what's your favourite biscuit and why?
Well, now that's a dilemma, because I'm not sure if Jaffa Cakes are biscuits or not, but they're a main weakness. I've always been a fan of ginger nuts, and if I could have to choose one, that would be the best. But I've been told to cut down on sugar and things, so I now go for the low-fat digestive, which I've come to enjoy quite a lot, even though they're a plain Jane type of plain Jane. So I'm sorry, I'm being indecisive, but my current favourite is the low-fat digestive.
Well, he did say you're being indecisive. I think it was Gordon Brown who he said took 5 days to decide. And I must admit, to me, it's one of them things where it depends what mood you're in. You can't have a favourite biscuit because it depends what mood you're in. You know, I'm probably Jammy Dodger, but if I fancy dunking something in, it's going to be something different. You know, so
yeah.
But I do remember when I used to work at Cedar and we used to mediate a lot in the IDRC. Biscuits were always too good. I too many biscuits. And I had one mediation once where the parties were very respectfully asking me to stay out of the room for a while they negotiated, which was fine. You know, it's their mediation, not mine. But I must have eaten dozens of biscuits that day. I was literally just sitting there eating the biscuits at the IDRC. They were very good, and I know they still are today, actually.
Yeah, it's just always difficult if you're trying to lose weight and you get a nice spread put out at lunchtime.
Oh, I know.
And the biscuits are always tempting you. Yeah.
Well, I'm one of those people who's been trying to lose weight for 55 years.
Oh, well, join the club.
Right. So the future. So as I said earlier, we had some time together on one of the AI for Mediators courses, and which I learned so much from, as hopefully the people attending them do, but every time we do it, we learn more. Where do you think the future's going for mediation in terms of technology?
That's a tricky question. We're in a time of great change. And I think I start off with saying, where is litigation going? Because one of the things we need to understand as mediators is what are the litigation solicitors and barristers, what are they doing with technology? We need to understand that. I mean, they could, for example, be using software to guide their negotiation offers as you go through a mediation. You need to be alert to that kind of thing. So I think understanding, being abreast of what's happening is important. I listened sometimes to Claire Fowler, who's a professor, works with mediate.com and odr.com in the States. And she says that there are several new AI applications applicable to litigation and mediation coming out each day. You know, so it's really difficult. But we're going to see, I think, a great change. AI tools will be used. When I first came across them, they were used for kind of back office stuff, either at the beginning of the mediation in the preparation and admin stage, or afterwards with the billing and invoicing and so forth. But there are now tools being used in mediation, which I'm learning about. So, for example, if there is an impasse, if the mediator and the parties so agree, and that's absolutely crucial, and informed consent is required, and there are lots of privacy and data considerations to be taken into account. But I have seen reputable mediators say, yes, we can now use AI to say, let's ask a large language model to generate some options. And we'll give it a neutral brief, We'll all agree on the brief, so it's not going to be slanted one way or the other. And let's see if it puts out some talking points which can be used. And I've seen the mediators who told me about that have said, sometimes I've been very surprised that there have been things which came out which I wouldn't have thought about, and which the parties have found very, very useful.
Yeah.
So I can see some benefits from that, but also there are many concerns at how this is going to be used. And I was thinking just earlier, Remembrance Day, 11th of November, men use machines to kill men. AI is a kind of machine, machine learning. Is it going to be put to good use or bad? And I think that's very important for us as mediators, because there's a temptation, I think, to sit back and say, well, I'll see where this goes and then I'll join up later on and we'll see what happens. But I think we have responsibility as mediators to be part of the development of ODR, online dispute resolution, and AI and how it's used, and what the limitations are.
Yeah.
How this is going to happen. So you bring in the ethical side. And if we don't get involved in setting the rules, then rules are going to be set by software developers for big organisations who say, here's your new mediation machine, do your mediation with us, and we'll go and crunch your everything. And if you don't know what's happening, how it's happening, why it's happening, that is very dangerous.
Yeah.
But on the whole, I'm an optimist, and I think that AI can be used for good, and I think that mediators will use it for good purposes to speed up hearings. I think efficiency is important, as well as the time being taken, as we referred to earlier. But I think there will be tools that can be used. There's one which I was referred to recently. I've heard about it several times. I continue to be dubious about it, and it's called something like Crystal Knows. And this is a tool that can be used and can give you an idea of the mood, feeling, or disposition of someone else on the screen. Well, that I find very intrusive. But the mediator who was telling me about that said, well, I've used it on myself, and I think this might be a useful tool in some circumstances. But I think this comes back to some of the basic essentials, which are, if you, whether you're a litigation solicitor or a mediator, if you're using AI, it's up to you to do it properly and to be transparent. And to say, well, I would like to use an AI tool on this, I shall need this data, this is what I will do, this is what it will do. And if there is consent, then why not give it a try? But I think anything which is kind of covert during the mediation, I think would be heavily frowned upon. And this is where regulation comes around, because we're not a regulated business or profession at the moment, and that has freedom for us to develop mediation and other forms of ADR as we think appropriate for clients. But it also means that if bad actors get involved and start doing things which you and I would say, well, that is just wholly against what should be happening, what do we do about it? So there are some very big questions coming up, and not just for us as mediators, but society as a whole. I'm applying this to personal injury and clinical negligence mediation. That's my prism when I look at this. But these questions apply across the board, I think. I'd be interested in your views, because your AI course I thought was very insightful that I attended. Are you an optimist or a pessimist, Greg, when it comes to the future?
Can I be both? I think AI is brilliant, but obviously you need to be aware of the dangers of it. And I think if I look back to when I started using some of the large language models, and I look at some of the things I did with it, I think, oh, shouldn't have done that, or that wasn't very well done, or whatever, because you're constantly trying to improve what you do. I think the danger, and I've seen this with some groups of people I've worked with, that it's the danger of using AI to build a claim, say, when you don't have the knowledge of what it's sending out in your name. So from a party perspective, so in the travel industry, for example, we're seeing more complaints are being generated by AI for consumers, and they started quoting different regulations and directions and acts of parliament and things like that. And when they get to the tour operator to answer the complaint, they don't make sense, and the whole essence of what the complaint was has been lost in this pack of, well, it looks clever because it's quoting acts of parliament, but actually it's not getting the information right. So I think there's a real danger in terms of party use. And I have heard anecdotal stories from mediators who've said, well, I was going down a line with a party and they've said, why are you talking to me about this? AI has told me you should be telling me this. So the sort of second guessing what the mediator's going to do based on whatever they've put into whatever AI they're going to use. From a mediator perspective, I'd love to save this podcast, which we will obviously, and come back in 10 years and see what's happened, because I think the optimistically pessimist side of me wonders whether there'll be mediators in 10 years, whether there'll be arbitrators. Is AI going to keep developing and keep getting better and better to the point where you see the lists of 100 different jobs that are going to go with AI. You'll never see mediator on that list because mediators don't get on any list. Mediators and arbitrators, because most people still don't know what mediation and arbitration is, which is another challenge for the industry still after all these years. But I think, are we in one of those sectors where AI will one day just naturally be able to do what we do?
Yeah, I've got an open mind on that. I think certainly for the next few years that there was going to be a role for mediators and arbitrators to play. I can see, if you look at the number of claims, potential number of claims that exist in the world, and if you think of a funnel, all those claims going to a funnel, I can think that many claims can be dealt with by software looking at the issue, saying, is there a claim or not? And yes, there is, and it might be this kind of claim, but actually there's a very low prospect of success, so you're better packing it up now. Or you've got a small claim, why don't you put it into an online negotiation session and see if you get anywhere? And all that kind of thing can be happening online before people actually get to the decision of, do I want to invest time, resource, costs in a claim? So there might be a much better filtering process, which is better for access to justice, if people are getting that information and getting that help, which the one-to-one one lawyer to one client simply can't do, and that's the access to justice problem. So I think there will be improvements in that regard, and I think that some simple claims may be very suitable for some kind of online determination, even if it's only an initial determination which is non-binding. But if you decide to go to court and go past that, you actually got to do better, or you're going to be paying some costs. But I think for the foreseeable future, there's going to be a job for mediators, for litigators, mediators, arbitrators. You say 10 years future forward. It'd be interesting to see where we are in 2 years, the speed at which things are going.
Well, I've got 10 years in my head because I'm 55 and I'm thinking I've got 10 years left working. I've got to make sure that mediation sticks around for at least another 10 years.
I think you'll be busy for that time, Greg.
Yeah. But I think it's one of the reasons why we're doing that course, and you've got a talk next week as well, which I'm happy to be speaking at, about AI and mediation. And I think it's one of the things that, I feel it's incumbent on me as someone who trains mediators and provides mediators to be able to say to mediators, look, this exists, parties are using it, you need to be aware of what parties are doing and how you can use it with the consent of the parties to help you in a mediation as well. Because I think people who keep abreast of AI are more likely to be able to have a role in the profession for as long as it goes on. where those who are just sort of burying the head in the sand and thinking, well, it's just another fad, it'll go, I don't need to worry about it, might find themselves in a bit more bother.
Sure, and that's why I appreciated your course so much. And I think it can be summed up in this kind of rather trite way of, will AI take my job? And the answer is no, but somebody with AI might. Yeah. And so you do need to be up there. And thanks for mentioning the webinar which we're Trust Mediation holding on 19th November. Some details are on our website, but we're going to take a look in some detail at the things we're talking about now.
Excellent. You've got some really good speakers. Do you want to give a little plug for the event?
Well, it's an international event in the sense that Colin Brannigan, who I first met back in the 90s when I decided to go into mediation full time, he was starting out as well. He's based in Toronto, and he's been very involved in mediation and MEDARB in particular in Canada, and he's followed through on the AI. So he's going to give us a take on what's happening as he sees it from Canada, but also the USA, and as well as yourself, there's myself and Phil Hesketh. Phil wrote our website many years ago and has done various clever things with Microsoft Power Apps and other things like that to make our back office work without too many strings and Keith Robinson devices. But we've got a fairly smooth back office now thanks to the work he's done. And having an IT mind like that gives you an insight into what's possible and what's not. So I think we're going to have an interesting conversation. We need to spend some time on the preparation still, because I think we could talk about this for 5 hours still not the subject. So that's something for us to talk about. But I think it'll be an interesting session, and I hope useful for those who are interested in AI in litigation and mediation, but also those who are not, to see what's happening.
Yeah, and it's free, isn't it?
It is free, yes. Free.
Yeah. So anyone who's listening who might want to register, as Tim said, you can look on the Trust Mediation website. You can also look on LinkedIn. Both Tim and I have posted about it. So, yeah, if you want to have a look at that, that'd be great. Tim, I think that's all we've got time for today. I've really enjoyed it.
Well, Greg, I've listened to many podcasts, including many of yours. This is the first time I've been on the other end. It's been an interesting experience. Thank you very much for having me.
No, not at all. It's been a pleasure. Excellent. And we will see. Well, I'll see you next week.
I'll be in touch about the prep.
Yeah, lovely.
You need to mediate, so don't be late. Arbitrate to enhance your state. Adjudication is your road to salvation. Hunt ADI is your destination. He's working from home. Yeah, he's working from home. For dispute resolution, there's only one solution.